Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments that have taken place in the last few weeks in the realm of international taxation. For this, we have selected three important cases. The first one discusses the taxability of license office of a foreign entity in India. The second one discusses the taxability of a sum received by the foreign company in lieu of support services as FTS. And the third one discusses the taxability of payments made for transfer of exclusive license as royalty. Our first case revolves around taxability of a license office of a non-resident entity in India which is engaged in core activity of selling, marketing and concluding contracts on behalf of such entity. Let's understand what exactly happened in this case.
The SSC is a foreign entity which has set up a license office in India for supply of aero engine and spare part to Indian customers. Being a non-resident, the SSC did not file return in India on the assumption that the income from sale of goods overseas was not taxable in India. The AO, however, noted that the office of the SSC is a fixed place of business at the disposal of the Indian license office, and it conducts core activity of marketing, negotiating, selling of the product. Hence, it was deduced that the SSC and its employees served as PE, and therefore 75% of the profit should be attributed to the PE in India.
Let's see what the tribunal had finally decided. The license office of a foreign company is to be treated as a permanent establishment in India if the former is engaged in marketing, negotiating and selling products for the latter, and where the former's employees receive orders exclusively from the latter. If it is found that the activities of a license office are attributable to those of a PE in India, then tax attributed to such activity must be made taxable in India. Moving on to our second case, the tribunal was approached to decide as to whether the amount received by the foreign entity in lieu of support services provided through its group affiliates can be charged to tax as FTS. Let's understand what exactly happened in this case.
The SSC is a non-resident manufacturer of food products with a portfolio of global brands. For the relevant year under consideration, the SSC entered into a global agreement with its group entities including Indian counterpart, wherein the entire cost incurred by the SSC for undertaking the support activities for affiliates were allocated between the affiliates based on allocation key. The dispute arose when no markup was charged by the SSC on the cost allocation. The department taxed the receipt of the SSC received as reimbursement by a group of companies as FTS.
Let's see what the tribunal had finally decided. To come under the category of reimbursement of receipts of service, the same has to fulfill certain criteria for which the services have to be provided by foreign entity to its affiliated companies. The concept of make available requires that the fruits of the services should remain available to the service recipients in some concrete shape such as technical knowledge, experience and skills. If service recipient makes use of technical knowledge by himself in his business and for his own benefits, then payments made for such services are to be treated as FTS. Now let's move to our last case, where payments made for acquisition of exclusive license to manufacture vehicles were taxed as royalty even though production has yet not started. Let's see what exactly happened in this case.
The SSC is a leading airline operator. It claimed to have sent its personnel to receive pilot and cockpit crew training to Dubai, Singapore and Germany. Since the training and payment for the same were all abroad, as well as it did not involve transfer of any technology to SSC's employees, it was claimed that such services could not be regarded as FTS. Here arose the dispute.
Let's see what the High Court had finally decided. Mere license or supply of technical information will not render the payments made for same as royalty unless such license is put to use. Payment for actual use of license cannot be taxed as royalty until production and sale has commenced by use of such license. With this, we wrap up this episode of Legal Wrangle, and next time we will bring some more interesting cases from the world of GST. Thank you for watching. Goodbye.